Sir. Good afternoon, everybody. Good afternoon.
Good afternoon, ma'am. Can you just once move one slide so that we can see?
Yes, just trying. 1 second. Is it okay?
It's not moving, ma'am.
It's not moving. What about now, sir?
Now also it is not moving. Ma'am, did you share it full screen?
Let me check it.
Now it is moving, ma'am. Now it is moving. But now I think you have closed the sharing. Please reshare, ma'am. The presentation is closed now. Okay.
What about now, sir?
It is now it is moving, ma'am. Now it is moving. Very good. Okay, ma'am. So, Sandeep, are you ready?
Yes, sir.
Okay, so please proceed.
Good afternoon to one and all present here. I extend a warm welcome to everyone to this insightful session on the lines of Samvad organized by Department of Law, a School of Legal Jurisprudence, University of Karnataka. It is an honor and privilege for me to serve as a moderator for this session. We are truly fortunate to have with us an esteemed chairperson, Nasima PK ma'am. Dr. Nasima PK ma'am is an experienced professional in India, now working as an assistant professor of law. She has experience in two top central universities of India, namely the University of Delhi and AMU, Aligarh. Currently, she is working at the AMU Center in Malapura, Kerala. She has worked in various capacities, including principal and vice principal of reputed women's college in the state of Kerala. Law teacher in a college, advocate, and researcher. With a teaching experience of 18 years and having published 35 papers as research paper in journals and chapters in books, and presented 17 papers in international seminars and 24 papers in national seminars, and being a frequently invited resource person, she continues her academic journey and now with the highest degree of commitment gifted this book to the society around her. Now I hand it over to Nasima PK ma'am to deliver lecture.
Good afternoon, everybody. I'm so happy to join you for such a selfless activity of dissemination of knowledge. First of all, I would like to congratulate Department of Law, Central University of Karnataka, especially under the leadership of Dr. Basavaraj sir and other faculties, and my dear friend Jayanta Bara sir, who has initiated such a noble work of disseminating legal knowledge in 100 lectures. In my experience of teaching for 18 years, this is the first experience of this unique mode. I congratulate all the faculties of the Department of Law, Dean sir and Jayanta sir. See, knowledge, I consider it as a gift of God. And when it is delivered pro bono, the beauty gets magnified. And it becomes more meaningful when we speak about Constitution. Because in the screen you can see our Constitution matters to us. Or in other words, we can say In a democratic country like India, where diversity you can see from every nook and corner, our constitution really matters to us. As you all know, it came out of a long deliberation, consultation with that time existing constitutions, taking all the virtues that have been reflected around our constitution that time. That is why we can say it is one of the most historic and influential document that the world has witnessed. And I need not elaborate upon before such a knowledgeable audience regarding the values in the preamble, what we wanted to achieve. These are actually the introductory part coming as a part of my introductory part of my lecture. Our sovereign, socialist, secular, democratic republic wanted to achieve justice, liberty, equality, and fraternity. See, how to achieve this? That is the issue that we face at many times on the practical level. We know that just now I told you that our constitution has been based upon many model constitution. But we all know everything will change. And there is only one thing that will not change, that is change. That we all know. In a democratic country, where the constitution controls all the organs of the government, may it be judiciary, legislature, or executive. In a country where the constitution is the touchstone of every law that has been made into, that country should equip its constitution to face any challenges of the time that it may face through. Or in other words, we can say, if it was meaningfully drafted, it should be organic, or it should have a phase of progressiveness. What do we mean by progressiveness? Progressiveness means whenever the time poses a challenge, whenever society needs an intervention of constitutional principle, there is no silence. Every time when the people of that country wanted to have a support from the mother document, it is vocal for them, it is available for them, it is full of meaning for them. So, in this way, what I wanted to convey is that constitution means an evergreen document. So the greenery should be added to it so that it will not become colorless. How to add it? Which wing has to do it? There are different opinions. It is the duty of legislature to do the addition work, modification work, beautification work. But there is something else that we are going to discuss in the form of the theory that just you might have seen the caption. So I told you, we all wanted our constitution. It is our constitution. We are its custodians. We are the sovereign. Just like preamble says, we the people of India. So we all are inheritors of this constitution. So you may see Justice Nariman Kavan quote. With this quote, let me open the topic. I hope you all are reading it. So we are just sailing to this Magna Carta of the Great Charter of India. How to make this document evergreen? Green is a word associated with a tree. In our title of the lecture also you can see living tree doctrine. So first of all, let me explain what do you mean by the living tree doctrine. As it is seen in the slide, it originates from a Canadian decision which is known as Person's case. There were 5 persons, 5 ladies who approached the highest court of Canada asking the court to admit them to the Senate, but it was rejected. It was rejected on a very peculiar ground. Whether we sitting in this platform cannot even think to that level nowadays, whether women are person or not. Our students will laugh at. But this case shows that, see the year, it is in 1929. In 1929, even in Canada, which we consider of much legal growth, that time the issue was whether women were persons or not. As I said, Canadian Supreme Court rejected it, and that time Privy Council was the highest body. These women went there, and then JCPC, Judicial Committee of the Privy Council in Britain, made a very meaningful deviation from the rule existing that time, and they ruled that women were indeed persons and they are of course eligible for the appointment to the Canadian state. So here we can see Privy Council is just giving a decision that women are also persons. But this lecture is not about women's rights alone. From that decision onwards, we can see a plethora of cases starting, and its reflections were resonating in different legal systems as well. In Australia, in US, in India, though our focus is how this doctrine has been reflected in Indian constitutional jurisprudence. That is our exact topic. So I request the audience not to think that this particular decision we are going to analyze on general justice route. No. Actually, this decision overturning the Supreme Court of Canada's ruling with respect to the BNA Act is known as living tree because of some metaphor. Metaphor, you know, in order to reflect or communicate clearly something, we used some contrasting words in English language. So that time Lord Sankey, who wrote this judgment for the JCPC, he used this word, living tree, and stated that BNA Act was like a living tree. What is the characteristic of a living tree? It can withstand the pressure of summer, winter, autumn, spring, whatever it is. So the judge said, just like a living tree, who is existence, who is capable of growth and expansion, this law is also like that, or law should be like that. This particular case opened the progress of women's rights, and Karen Wilson was selected as the first woman appointed for the Senate of Canada. That was a change happened there. And after that also, this doctrine was applicable in Attorney General versus Carter in 1991, when in Canada, some voting rights were challenged. There also the judge said, see, past plays a critical role, but at the same time, we have to say goodbye sometimes to the past. The tree, the law is equated to the tree. Tree is rooted in past, but in present as well. But it should extend its branches to the future also. I hope my beloved audience got the point. Law is equated to a tree. where the tree cannot take its roots from the past. It has to be in the present, but it has to be inclusive. It has to think beyond the timeline. It has to grow. It has to be organic. It cannot be imprisoned in the past, neither in the present. This is exactly what the judge meant in further taking up this living tree doctrine in 1991 in Attorney General case. See, we were speaking about living tree doctrine, and I already explained that it originated in Canada, and we discussed a 1991 case also. What about other jurisdiction? It is not an exclusive characteristics of Canada. When we go to comparative constitutional study, several jurisdictions, US, Australia, and when we discuss in Indian constitution, then you will understand. In all this legal system, there was a concept that constitution is a living thing. It is not frozen. Even if you have to keep it in the original form, you have to maintain it crossing the time and the geography. So this living metaphor, this tree wala example, living metaphor was not only present in Canada, but it was present in America too, as well in Australia and India too. What would have been the reason for pulling the hands of law using such a metaphor? What would have been the reason? See, if you consider Canada, US, Australia, and India, in all four constitutions, you can see they are very lengthy and very rigid too. So maybe there can be some other purpose as well, which we will discuss, the purpose of social justice. But initially the purpose was to keep pace with the societal development because of the rigidity and lengthy nature of the constitution. Just let us have, before going to Indian scenario, just let me tell you some American experience. See, in Magdala versus Maryland, the Chief Justice was Justice Marshall. He was deciding a case on constitutional law. Then he used one quotation, a fair construction of the whole instrument. And he extended by saying that US Constitution is intended to endure for ages to come for managing human affairs. So these two things, for ages to come. So you have to update it. You have to read the Constitution, not strictly adhering to its literal terms. Don't focus on alphabets alone. Try to find out the spirit, the meaning that is hiding behind the alphabet. That exactly the judgment. But there you can find a difference. In America, when they decriminalized sodomy, Supreme Court of America did not step into it in a quick fashion, but they declared it decriminalized only after the legislature has taken, many state legislatures have legalized it. That means what I wanted to note, the difference in American theory of this living theory of the Constitution, even though the judges used the theory, but with caution. So they considered doctrine of living constitutionalism about constitutional development with an interaction of the courts with the political branches. Please note the point. So the UX experience is a little bit different from Canadian experience, and it is entirely different from Indian experience. So what is the speciality of US interpretation of the living theory? They considered it not as a interpretational rule. Instead, they considered it as a process of constitutional development by the cooperation of the court and the political branches. not as a duty of the courts alone. See, Balkin, who is a very famous legal scholar of America, he wanted to differentiate the traditional living tree theory by saying that it is not a theory of constitutional interpretation, but a constitutional construction. So while in Canada, living tree doctrine is purely considered, understood as a tool of constitutional interpretation, in America, they use it, but as a constitutional construction. And of course, it can be carried out by both political and judicial branches. There is no exclusiveness for using this doctrine by the judiciary. They consider it is a mixed task of both political branch and the judicial branch. I just mentioned this for your understanding. So, how we are going to tackle this theory? We are going to see this theory, we are going to analyze in the lecture as an interpretational tool. Or in other words, we are going to articulate living tree doctrine as a principle of constitutional interpretation only, which will help the constitution to grow, to adapt, making constitution little bit broader, liberal and progressive, so that constitution can come out of the pages where it sleeps and it can come to the streets, it can come to the kitchen for doing justice, it can come to the classrooms, making the theory of equality practiced. So like this, living tree doctrine analysis purpose, it is purely a theory of constitutional interpretation. What are the three principles of living tree doctrine? I hope all of my audience is getting the point. Living tree doctrine originated in Canada. The short summary is that law should be understood in similarity of a tree which should grow, which should come out of the words, etc. Now the key principles of doctrine of living tree. First one, organic constitution. I'm not elaborating it because we have to cover many points. I have already told. Constitution, आपका viewpoint में, in your view, what is it? Is it a paper? No. It's a paper. It's a document, but it is having a soul. It is having an energy in it. It is having a life in it. But for the time being, it is sleeping in the books. So, view of constitution as an organic, like a seed that will grow. Then second, when you approach this document, how to read it? That is the second principle, that is progressive interpretation. Living tree doctrine asks you to read it with a progressive mind, to change the society, to face the new circumstances. Then, what is the purpose? Purpose is not the literal meaning, but beyond that. So, these are the three key principles embedded in the living tree doctrine. Now, let us go to the Indian scenario. Why should we discuss in India? Is there any application for this theory in India? First of all, for a law student like us, there are two important sides which makes the theory relevant. One is judicial relevance. Being the students of law, we all have to study what the Supreme Court is doing, because they are making precedents, and precedents are the source of law. So we have to understand that. So our Supreme Court is implicitly and explicitly applying this doctrine. So that is the relevance. Second thing, human civilization changes, and constitution is the grand norm, basic norm. So the social relevance of the constitution is always there in the field. So this social relevance also makes this theory important in India. What exactly this theory is helping us to do? Simple. It helps us, especially the judiciary, to build an egalitarian society, and that work is not at all finished. Just like now it is October, we all are remembering of the father of our nation, Mahatma Gandhi, who said, our basic duty is to wipe tear from every eye. So long as a single tear is there, stayed in any citizen, in any person, our work is not done fully. So this purpose of this doctrine from every eye, which is not a simple task. Next one, whether there is any jurisprudential existence for this doctrine in India in constitution? Of course. There are some seats. Of course, it is the judiciary who is using the tool, who is applying the tool, bringing different colors of law through different case laws. But our framers of the constitution also had put this seed. It is not a judicially found out tool when coming to Indian constitution. See, our constitution makers, one example, please take the provision for amendment. We all know provisions for amendment in the constitution is having two different features, contrast features are there. One is flexible and the other one is rigid. Flexible, you can amend the constitution, many provision by simple majority, but many other provision, you have to get special majority. So that itself is the seed of this doctrine in the jurisprudential makeup of our constitution. And the length of the constitution allows adaptability. Then preamble also, see, preamble, whatever words we have used, the one word is having thousands of meaning, which we are going to discuss. Liberty, what is liberty? Liberty to sleep when you want. Liberty not to talk. Liberty not to sing the national anthem. Liberty not to disturb others. Equality of different colors. Equality in education. Equality in having good air to breathe. There are so many. So which means that each word is pregnant with different meanings. This trick, using some words, have been already put. This seed was there in the jurisprudential makeup of our constitution. So my simple point from this slide is that this doctrine found the jurisprudential existence in our constitution itself. Now comes the man of the match, judiciary. See, Indian judiciary has played the most active role using this doctrine, though in the final part of my lecture, I would like to differ a little bit from whether judiciary has used this theory or a different version of the theory. We know why Supreme Court should step into. Because we, the people of India, has given the custodianship of the constitution in the trusted hands of the judiciary. That is why we all know judicial review is the basic duty of the court. And so while exercising this basic duty, Supreme Court has made the widest possible interpretation for many legislation depending upon the circumstances of the case. So I would like to share one point that the traditional role of interpreting and review the law. This is the basic role. But that has been equated to keep the constitution dynamic. So the role of the judiciary is shifted from simply an interpreting machine, say, to someone who keeps the constitution always dynamic. So that role change, fixing its hands in the basic role of interpretation, Supreme Court has moved to make the constitution dynamic using some tactics, some principles, some doctrines, and living tree doctrine is one such doctrine. And see, if it was a purely egalitarian society, there is no need of looking beyond the law. We all might have heard that in a perfect society, law will wither away. Plato, you all know that. But the concept of a perfect society will not exist. I don't know, in some golden times of the future, such a society will come where everybody knows our rights and duties equally. But so far, it has not become a reality. So the social realities of India necessitates our Supreme Court to step into. Like, when independent India was very young, there were so many issues of Zamindari system, distribution of resources. Zamindari Act were passed, Land Ceiling Act was passed, right to equality versus right to property, confrontations were there. And you can see when we go to the analysis of case law, after discussing this theoretical background, then you will see how the Supreme Court was interpreting initially, literally focusing on the words when right to property and right to equality was confronting each other, and how its tone was changed later on. So I hope you could take away the point that I was thinking of conveying. The social realities in India, especially after the independence and even now, necessitate Supreme Court to have a lens of this doctrine to make things more right and more enjoyable. But we used to think that on an occasion, I also thought that the Supreme Court started using this tool after the independence. It is not correct. Pre-independent India also has witnessed the usage of this doctrine. In 1939, in central provinces and Berar sales motor ka case mein, that time Sir Goyer was the Chief Justice. See his statement. A constitution of the government is a living and organic thing. It is a pre-independent time ka case hai. Judge is speaking about GI Act 1935. The concept of federalism in the GI Act made the judge, using the word, we have to think a broad and liberal spirit should inspire, whose duty is to interpret it. See, broad and liberal spirit, this is exactly the living tree doctrine also. At the same time, that time the judge is giving a caution also. See, please see the last sentence. They were not free to stretch or pervert the language of the enactment. With a word of caution, in 1939 case, Sir Maurice Goyer is telling, judge has a duty to go for a broad and liberal spirit, but he should not go freely to stretch to any level that he wanted to go. So the doctrine of living tree has came to Indian jurisprudence in 1939 itself. Thereafter, in 1952, State of West Bengal versus Anwar Ali Sarkar, please see what Justice Vivian Bose is stating. Without regard to the background out of which they arose, as they were not just dull, lifeless words, static and hidebound as in some mummified manuscript. So he is telling it is very difficult to interpret the constitution in a mummified manuscript. But it should be read in the living flames intended to give their life to a great nation. So when the judge is expected to sit in interpreting the constitution, they have to again and again remind that this is not a mummified manuscript, but it is a living flame. Aspirations, dreams, or a dynamic fire to guide the future of the citizens of India. So I think you might have noticed in 1950 West Anwar Ali case also, court used the living metaphor. So flexible interpretation के लिए, in order to interpret the constitution in a flexible way, this living metaphor was used in 1939 and in 1952. Now, there are some fixed areas which has been very much beautified by the judiciary using this particular doctrine. We are going to discuss one by one. First one, let me discuss area of amendment. Then fundamental rights. A little bit quickly we have to go. Isn't it, Jayendra sir? 5 we have to finish, right sir? Hello?
Yes, ma'am. Yes, ma'am.
Yes. Okay. See, in amendment, you all know Sajjan Singh. I'm changing the slides, hoping that you all know Sajjan Singh, Golaknath, etc. But just only one word. Sajjan Singh, court interpreted that amendment can go to any level. You can mute the fundamental right, you can change it, modify it as you wish. But in Golaknath, the doctrine was restricted. Living tree aspect of the doctrine was restricted, and said rights are immutable. You cannot touch it. Or Golaknath created a constitutional deadlock. It has frozen our constitution's adaptability. Then, a judicial saga is coming after 20 years. After Anwar Ali, after 20 years, Keshavananda Bharati case mein, this doctrine is explicitly used, saying, I'm not elaborating as you all know that, Parliament can amend the constitution even to abridge, so long as the basic structure of the constitution is retained. That means it is a direct application of living tree doctrine. Go to any extent, amend the constitution, but keep like a kite flying in the sky, keep the string within the basic structure. So long as you are not destroying the basic structure, your flying around is well permitted. A very clear application of the living tree doctrine. So my learned audience, please understand, from Sajjan Singh to Keshavananda Bharati, we can see the application of the living tree doctrine, but with different magnitude. But finalizing in Keshavananda Bharati, clear-cut application of this doctrine, thus it prevented both rigidity and fluidity. Sajjan Singh was so much of fluidity, Golaknath was so much of rigidity. That balance was reached using this beautiful doctrine. It's very interesting to note that in Keshavananda Bharati, court was, in page number 1431, many times they are referring GI Act, American Doctrine of Living Constitution. You can see they are quoting Justice Carl calls sentence, then Justice Holmes को भी quote कर दिया. It is not a mathematical formula, but they are having their own forms. And even Nehru's speech in Constitutional Assembly was also quoted in Keshavananda Bharati. So this dynamic charter was reached using this doctrine. And Chandrachud, Justice Chandrachud concluded by saying that Constitution is a living organism. So there is a comparative table which you can refer how from Sajjan Singh to Golaknath this doctrine was used. Thereafter, we can see an era of conflict versus conflict. There were two types of groups, judicial activist and political activist. One was for defending the constitution, one was for progressive development. And thereafter, you can see from Indira Gandhi, Minerva, Vaman Rao to Bhim Singh, you can see the change in the judicial attitude. Sometimes conservative approach, sometimes liberal approach. And in Indira Gandhi, extending the principle of Keshavananda Bharati, we know that judicial review was considered as a basic structure. And then then Minerva Mills, limited power is a part of basic structure. Vaman Rao, IL Kholo, these are other case laws where judiciary reaffirmed its living tree principle for extending the basic structure. So excuse me, sir, anything to me?
No, madam. No, madam.
Okay. So each brick, now we can see the basic structure is a beautiful base. Different colored bricks have been added to it in the form of limited government, in the form of judicial review, etc., etc. These bricks were added to it using this weapon of theory of living tree. Another area is fundamental right. A little bit quicker, let me go. From A.K. Gopalan to Maneka, there is a long distance that our judiciary has walked. From a judiciary who was not even ready to accept the procedure established by law should be genuine, should be reasonable. From a black Austinian interpretation of law, which says that we just need a procedure only to hang you. We are not bound to go behind the procedure. Hey, आपके पास एक procedure है on the table. Whether the parliament has passed a procedure, but that is enough for us to hang any human being, to arrest any human being. This type of black interpretation of law say, to reach Maneka Gandhi, judiciary has of course relied on this beautiful doctrine. You know, I'm not going deep into Maneka Gandhi, where their life is equated to a dignified life, not a mere animal existence. And many cases under Article 21, as the slide is clear to you, Francis Corali, Oliga Tellis, Unni Krishnan, a Vibgyor like. We all have seen the beauty of the Vibgyor. If it was only single color, it will not appeal to our heart this much. But Article 21, to any new person who see Article 21, its growth from 1950 to up to the date, you can see small but great, meaningful additions stitched to the meaning of Article 21 by the judiciary. Right to dignity, right to livelihood, right to education, etc. So, first was fundamental amendment. Now, though, fundamental rights, especially Article 21, where judiciary has used this. Now we are having a full-fledged, beautiful environmental jurisprudence. We were not having it. Now, when we throw our waste food to the road, we are remembering public trust doctrine, polluter pay principle, precautionary principle, absolute liability. And we think, I mean, only persons who think, others will not get these concepts. If we think we can understand the river, its water, oxygen around us is not mine. I have to save it. I have to keep it. I should use it only what I need. I should not poison it. If I do so, I am actually violating the rights of future generation. See, our thoughts are going to the future generation who are not yet born. This is the beauty of environmental jurisprudence, how it came to our life through many cases. Ratlam, Subhash Kumar, MC Mehta, Vellore citizens, right to environment, pollution-free environment, sustainable development, all these ideas our brains are containing now because of the contribution of the judiciary. There are so many rights. Privacy is such an important right for me and you too, Justice Puttasamy. Then many other rights, equality rights, decriminalization of homosexuality. There was a time where they were considered subhuman, not human at all. Now they are coming out. In NALSA, transgender rights, decriminalization of adultery, whereby the women were equated. Women's right, actually, that is a very interesting case in family law. Criminal law. Decriminalization of adultery still stands good for family law. That's another thing. But so long as criminalization of adultery, when we are discussing, there is an equal right for women too. If you are denying this right to a female, then you have to decriminalize it. This idea, if you right to life is more important, right to die is also important, common cause. So all these decisions, you are well aware of it. This is the contribution of this beautiful doctrine. Then public interest litigation, there is no need to explain it to such an intellectual audience. So I'm not daring to do it. You all know public interest litigation ka base was paved by this doctrine. S.P. Gupta, locus standi, strict adherence to locus standi was removed. No need for you to be the victim to approach the court. This was held in S.P. Gupta. Child rights, Bandhu Mukti Morcha, and human rights, ADM Jabalpur. So, gender justice, many case laws I have kept for your reference. And also, another point, let me tell you, see, it was this doctrine that gave an eye for the Supreme Court to imbibe our international obligation into the Constitution. So, amalgamation of ICCPR, UDHR, reading Constitution in tune with the UDHR, interpreting UDHR in tune with Part 3 of the Constitution. This reading a national document along with an international document. It was this doctrine that made it possible. See, there are many rights which are in covenant now as fundamental right. It is held by the Supreme Court. Even if such a right is not mentioned explicitly in the Constitution, it is there. Because India is a party to this international covenant. Right to speedy trial, legal assistance, right to have human dignity, compensation, many are there. Kindly see the cases also. Some of the cases which have been recently developed is, you may be knowing triple talaq. It do not have a constitutional standing, neither it is having an Islamic jurisprudence ka support also. But more than 160 years, it was continued in the subcontinent. And it was held unconstitutional. Even though personal law is legally accepted within the constitutional jurisprudence, something which is against the spirit of the constitution was declared unconstitutional. Shabarimala temple case also, you know. Now see, this much beautiful work has been done by the judiciary. In some cases, it has sat like a legislative organ. In Rajasthan, when a lady was raped so brutally, there was a legal vacuum, you know. The Supreme Court itself made a committee. Though the result is actually enjoyable for a citizen, let us analyze whether it is right to do like this. There are some criticism also against the very wider usage of this interpretational tool. See, of course, it is a judicial overreach. Judiciary is not a democratic institution. India is following parliamentary democracy. So the judicial overreach, if it is allowed, it will go to rewriting the constitution. That is one criticism. Another criticism is that there is a parliament to do it. Let them do it, not the court. And the court means judges. Judges may come and go. Personal philosophies, personal interpretations, if it is allowed too much, there is high risk of subjectivity. But this happens because of the inactivity, inefficiency of the other two organs. That is also there. But even then, when we approach this super smart judiciary, in some cases we have to say that there should be a limit as well, because it will hamper parliamentary democracy that India is following. Now, I will share some of the cases. See, the theory of living tree, court is not using the same word. It is very interesting. In one case, it is calling constitution living entity, Kyoto colon. In other case, it is calling living moral. Then another metaphor, living framework, sacred living document in Puttaswamy. Then this metaphor is used state power also. In Central Vista case, it is using living and dynamic. Matlab, what I mean is, Supreme Court is not consistent in using this metaphor. The words are different. In another interesting area, in section 377, when the first matter came in Suresh Kumar Kaushal, Supreme Court was silent. There was no reference at all to the living nature. Even though the council begged, council requested to using specifically this living nature, court rejected it. But when Navtej Singh Johar was dealt with, Supreme Court changed its tune. And when you read the judgment, you can see there is an extensive use of the living metaphor under the ambit of 21. So both were of the same nature. So that is why it has been criticized. Judges first identify their desired resolution, perhaps due to personal ideological preferences, then only they are using this metaphor. It is a criticism in this way. So what is the result of this doctrine? I have to conclude. Our country's rule of law has reached a new horizon. Constitution became dynamic. Now, let me conclude. We, the citizen of India, we, the people of India, has been gifted with a green tree in our hand. That's our constitution. With a vision they have given. There are so many challenges that our constitution faces. Once the best gift is given, it is for us to keep it. How? By walking along with its provisions, by breathing its spirit for us. I used to tell my students that constitutional morality or constitutionalism you can practice even on roads. When you give a hand for a blind man to cross the road, or when you smile a person who is suffering, helping him to smile again. When a person is dying for food, sharing your food. When your mother tries to discriminate between boys and girls in drawing room, kitchen, telling her about gender justice. In a classroom, when a teacher practices equality in marks, in attendance, when the students respect the teachers, respect theory jurisprudence. Here, in all this, when a husband respects his wife, when the wife too do the same, actually everywhere in these examples, we are making our constitution living. I hope all of us can add a little bit meaning to the constitution, though we are not using this living tree doctrine judicially, but the message, the request to you and to myself is that let us be able to keep the spirit of this doctrine in our day-to-day life and uphold constitutionalism in our life. Thank you, sir. I once again would like to thank Jayendra sir, whose spirit and sportive nature, I do not have any words other than to salute it. Beautiful ideas. This lecture itself is a contribution and a service to the Constitution. Thank you, sir, once more. Thank you. Thank all of the audience for patiently listening to my words. Thank you all.
Thank you, ma'am. Thank you, ma'am. It was a nice session from you, ma'am. Now, may I request Sandeep? Sandeep, are you here?
Yes, sir.
Okay, please proceed.
On behalf of University of Karnataka and all the participants, I extend our heartfelt gratitude to them on high and fundamental rights.
Hello there.
Doctrine and procedures fight has truly had and all the participants for and involvement. You have made the second request all the participants of feedback. With this,
Sandeep, Sandeep, your voice is not coming. It is okay. You can stop. In the meantime, I would like to extend my sincere gratitude to Nasima ma'am for giving us her valuable time. And the topic that you have explained was really interesting. I hope all our participants might have enjoyed this topic. We are streaming both on Google Meet and YouTube also. And we'll share those resources in the website also. And as I have already mentioned, this is a series of 100 lectures distributed in 10 different phases. So next Friday we'll again come here And I take the privilege to thank our Honorable Vice Chancellor Battu Satyanarayana sir for giving us this opportunity. I would also like to thank Dean Basavaraj M. Kubakadi sir, who was there also. I have seen him. He joined in between. Out of his busy schedule, he has given us time, and he has also supported me in all of whatever manner he can. I would also like to thank all my senior faculties, Dr. Anand sir and Renuka ma'am, for assisting me in all the possible manner they can. At the same time, I'd also like to thank Krishna, who is actually the backbone behind organizing these sessions, because he has arranged this link. He has made this link available in the YouTube also. He is silently here, but he is a person who is recording the screen also. So he has managed everything for this session, and all the other research scholars and students who has assisted in all in their respective capacities. Most importantly, I'd like to thank Sandeep, because 1 hour before only I have informed him, and he has taken up this call, and he's tried his best to moderate the session, and he has beautifully done it, starting from the introduction of the resource person till the conclusion of the event. The feedback link is there in the Google chat box. All the participants are requested to fill out the feedback form, and it is also informed that in no cases will share the same link anywhere else. So it is your responsibility to fill it up. Otherwise, we won't have the details to provide you the certificates. It's necessary. So once again, ma'am, thank you for giving us your valuable time, ma'am. It was nice learning from you. It was very much interesting also. Thank you, ma'am.
Thank you, sir. Thank you all. Salute the department once again for such an initiative.
It's our pleasure. Ma'am. This initiative will be fruitful with your support, all of your support, ma'am. We'll need your help also.
I should say that it's my constitutional duty as well.
Yes, yes. Thank you, ma'am. Thank you, ma'am. See you next time, ma'am. Again.
Okay. May I leave the session?
Yes, ma'am. Yes, ma'am. Yes.
Thank you. Thank you all.
So the session is concluded hereby. Thank you.